everybody. Can I just check? I can see Rose. Not sure I can see Lord Justice Arnold.
I'm here.
Very good. Can I ask my clerk, please, to call the case?
In the matter of A3 2020-0091, Warner Music UK Limited v TuneIn Incorporated, hearing day 2.
Yes, Mr. Howard.
Yes, my lord, I should just mention I've switched microphone today to a lapel microphone, which I hope will reduce feedback from home interventions from the court. I understand that Lord Justice Arnold was getting quite a lot of feedback. But if it means that you can't hear me clearly, then please let me know. My lord, my lady, yesterday I was addressing you on the question of the judge's findings and conclusions in relation to the Category 2 stations. I was just going to complete that topic before moving on to the next, which is the question of targeting. Summarising the position on the Category 2 stations, as I was saying yesterday, the task for the judge was to decide in relation to each of the sample stations if the station was operating unlawfully, firstly. Secondly, if the station was operating unlawfully, did TuneIn know that it was operating unlawfully? And thirdly, if TuneIn did not know it was operating unlawfully, should it have known it was operating unlawfully? The problem with the judge's findings in relation to Category 2 is, although he concluded that the GS media test was met in the sense that TuneIn had not rebutted the presumption in relation to it, that's at paragraph 158 of his judgment, page 156 of the core bundle, he didn't make any of the necessary findings in order to reach that conclusion. As I pointed out yesterday, firstly, in relation to all but 2 of the Category 2 stations, the learned judge concluded he couldn't decide whether or not they were operating unlawfully. It followed from that that there could be no further findings made about those stations, because until it was determined that they were operating unlawfully, the question of TuneIn's knowledge couldn't sensibly be considered. In addition, of course, it would be surprising, to put it at its lowest, if the position was that although the judge, having had the opportunity of substantial evidence and submissions, was unable to determine on the basis of the material and the submissions and the evidence before them whether those stations were operating unlawfully, that somehow TuneIn ought to have known they were operating unlawfully. Given the difficulty the judge had in determining that question, it was difficult to see, if the judge had proceeded to try to consider the presumptions, how he could reasonably have concluded that TuneIn ought to have known that those stations were operating unlawfully. But the point didn't arise, because without a determination that they were in fact doing so, the further question of the remaining questions, TuneIn's knowledge and what TuneIn ought to have known, did not arise in relation to those stations. In relation to the 2 remaining stations, which were the Capital FM station, and that's the Bangladesh station, and Urban 96.5 Nigeria, he found he was able to conclude that they were operating unlawfully. But having done that, at no stage in the passage in his judgment dealing with Category 2, from paragraph 143 through to 160, did he consider the essential questions he needed to decide in order to conclude what the position was in relation to those Category 2 stations, namely, did TuneIn know they were operating unlawfully, and if so, or if not, ought they to have known they were operating unlawfully? And again, absent any such findings, there was no foundation for the judge's conclusion at paragraph 158 that TuneIn was not able to rebut the GS media presumption in relation to the Category 2 stations. There's simply no foundation for that conclusion. in the judgment because the judge considered the matter in a way that didn't address the correct questions and later make the necessary findings. My Lord the Master of the Rolls asked me yesterday whether that was something we had covered in our grounds of appeal, and I just looked up the point. We have covered it in our grounds of appeal at paragraph 27, which is page 16 of the core bundle. And in particular, at the top of page 17, I won't read the paragraph out, but as one can see, the grounds of appeal make the point that I'm making now.
Yeah, that's okay. No need to spend time on that.
Now, in addition to that, in the same part of his judgment, the judge also made findings about the question of acceptance of TuneIn's terms and conditions and station update forms, which showed that he had become, unfortunately, confused about the nature of the evidence. What the judge has done is he's confused two quite different processes. One is the new station form, which was used when new stations applied to be on TuneIn's platform after a certain date, which is 2013 to 14. And the other is the station update form, in relation to which there was dispute on the evidence, which the judge resolved in favour of the claimants, as to when the station update form required parties who used it to accept terms and conditions. And he ran those two forms together. He started out keeping them distinct, but then ran them together in relation to his findings as to when parties or entities might have accepted the relevant terms and conditions. The passage in question is on page 155 of the core bundle, and it's the paragraphs 150 to 153. Now, given the lack of, as I say, given that the primary point is the judge didn't make anyway the necessary findings about TuneIn's state of knowledge in relation to the Category 2 stations, it may be that this point, at least in relation to Category 2, falls away, but these findings, it also appears, affected the judge's subsequent assessment in relation to the issue of authorization. So I'll deal with it briefly here. The starting point is to look at Ms. Robinson's evidence in her first witness statement, where she describes how stations were added to the TuneIn directory. It's in the supplementary bundle at page 148, which is tab 14 of the supplementary bundle. I'm sorry, it's tab 13. The statement starts at page 144, but at 148, Ms. Robinson set out some evidence about the way that stations were added to the TuneIn directory. And summarising what she says there, one can see the process is set out. She arrived in 2011, she says in paragraph 13, and when she arrived there were already a directory of stations, and she didn't know how that had been compiled, but she understood it had been added up to that point in two ways: third-party companies who added the stations, as a result of users asking for stations to be added to the directory. And then she notes by the time she joined, TuneIn wants to put in more structure and formality around its directory. And so around the end of 2011, 2012, TuneIn made a policy decision the station should only be indexed if, and three things happened. Firstly, the broadcaster became a partner broadcaster, so that's a particular agreement with the broadcaster. Secondly, alternatively, the relevant broadcaster completed a new station form. Or thirdly, via an aggregation licensing arrangement, which doesn't really feature elsewhere in the evidence. There are a couple of them, but they don't take matters much further. And then she notes, however, it wasn't until 2013-2014, the TuneIn service providers ceased adding stations. And after that, those three methods were the only way. So at that point, as it were, a gatekeeper was imposed in the form of the new stations form, which meant that people who joined using the new station form from that point had to tick the terms and conditions. And she deals with that in the next section of her evidence, from paragraph 16 through to 18, also quotes from the terms and conditions. Now, separate from that, of course, there was still a number of stations that were already on the TuneIn platform prior to 2011, and if they weren't joining new, they wouldn't have filled in a new station form, and therefore the question arose as to what happened there. And she deals with that in the next section of her evidence, where she explains there was a directory review, page 151 in 2018, and a little bit further down, she then moves on to the station information included. This is page 151. At paragraph 29, page 152, she turns to the update station form, which is the separate process. And there she explained that any index station that wanted to update the information they had relating to it, the update station form, had to fill in an update station form. And she said that also required the entity submitting the form to confirm it accepts the then current version of TuneIn's terms and conditions. And as a result, any station not previously signed up to the terms and conditions, for example, because it was added prior to 2011, is likely to have signed up to them subsequently on each occasion they use the update station form, which then goes on to explain when various forms were filled in by some of the sample stations. And she also notes at the end of paragraph 31 that she reviewed the systems, and TuneIn received over 600,000 new station and update station forms between 2011 and 2019. And since 2018, they'd received 25,000 update station forms. Now, just pausing there and following it through, that was reflected in the re-amended defence, which is in the core bundle at page 233. This is tab 13 of the core bundle. Between paragraphs 24 and 24C, 24A explains that from around February 2014, the new station form had to be filled in, and therefore it's to be inferred that after that date they must have accepted the broadcaster terms. And then at 24C, turning to the update station form, at the bottom of that page, you find the origin of the debate about when, or dispute about when, the update station form required terms and conditions to be ticked. Because at the bottom of that page it says, since at least September 2016, all published versions of the update station form have required station operators, etc., to accept and agree with broadcaster terms. So there were two forms in play, and in fairness to the judge, this is a point of detail in the evidence, and of course he hadn't heard the evidence himself. He was hearing submissions on the basis of the written materials and the transcripts of the evidence. Therefore, it's the sort of point that possibly could become lost. However, what occurred when he came to make his findings is he conflated two. There was no dispute that the terms and conditions applied in relation to the new station form in 2014. There was, however, a dispute about when the terms and conditions applied in relation to the update station form. It would have covered stations who were then updating their information subsequently, that wouldn't have concerned the new stations. And in the section of his judgment of paragraphs 150 to 153, he ran the two together. One sees in 150 he notes TuneIn's position that since February 2014, middle of that paragraph, all new stations are required to put a new station form. More generally, all other stations are required to accept broadcaster terms. And then the claimant submitted this evidence to not reflect what had really happened. That he talked about the bespoke agreements and the manner in which the stations would indicate their acceptance was by ticking a box. Then he continues, however, there was a dispute about when that was introduced. The claimants contended it was in September 2016, did not apply beforehand. Ms. Robinson said in cross-examination it applied to the station update form since 2011. Wasn't quite what she said, but it doesn't matter for these purposes. And then he says, I'm not satisfied it was introduced earlier than 2016. The claimant submitted this means tens of thousands of stations never tick the box. I accept that. Now, the problem with that is the judge has conflated the two different forms. There was no dispute about the introduction of the terms and conditions box in relation to the new station form. There was a dispute about when the tick box is included in relation to the station update form, but the judge ran them together and therefore based his finding that that tens of thousands of stations never could tick the box on the basis of that conflated evidence and misunderstanding. And similarly,
is there any evidence as to what proportion of radio stations in the directory predated 2014? I don't know whether almost all the stations were already on, presumably the BBC stations, which we saw are the great majority of listeners, predated 2014, but how many stations had been added filling in the new station form?
Well, there may have been evidence about that, but I don't immediately remember what it was about the precise breakdown. The thrust of TuneIn.
Well, broadly, was it 90%, 10% before and after 2014, or equal, or do you have no idea?
Well, again, I'm going on my memory, and I have to check the point, which I can do. I have a vague memory of there was a substantial number of stations prior to 2011. It was certainly tens of thousands of stations prior to 2011. The figure varies from time to time because some stations come off and some go on. But there were a significant number when the service was, when Ms. Robinson joined the service in 2011. I can't be more precise than that without checking the evidence, I'm afraid. But the point is, the thrust of TuneIn's evidence was they introduced more rigor in the station update, in the signing on system from 2014. And that covered the new stations that joined. Also, people they had a particular partner agreement with. Obviously, they had particular agreements with in relation to terms and conditions. But the question of the station update form was relevant, as your ladyship has noted, to the legacy stations that were already there. And the point that Ms. Robinson was saying as well, a very large number of these have been completed. Every time someone updates their URL address or anything about them, their genre or the details about the station, they're supposed to fill in the station update form. And a very large number have been completed. That leaves open the question of what number were completed prior to 2016, September 2016, and what number were completed after. And in relation to that, I'm not quite sure what the figures are, or whether it was in fact addressed directly in the evidence. But the problem is the judge, it appears, lost sight of that distinction, which is important between the different forms, and made a generalised finding in relation to the numbers of stations, and also that's followed through in para 153. He says, I find a substantial number of stations indexed by TuneIn have no warranty associated with them, and TuneIn is aware of this. But that's part of his compendious finding based on the mistake that I've described in relation to the tick box applied to both forms. Connected with that, the judge also took, we say, an erroneous approach in relation to, in the following paragraphs, in relation to the question of the status or importance of warranties and the terms that TuneIn had with particular stations. In para 154, he notes in relation to a number of stations, the terms are not in fact a warranty, the appropriate licenses have been obtained at all, but rather statements the sole responsibility for obtaining the licenses relating to public performance in the relevant territory rest of the station, and these included agreement with Global Services, and that's a large UK operator, Jazz FM, similar, some agreements abroad with Sweden and so on and so forth, and the one in Canada. And he noted that the one with the BBC contains an express clause excluding any warranties. Now, just leaving the precise detail of all those agreements on one side, there's a more general point in relation to the judge's finding here, which is that it's difficult his decision or his view that those types of agreements where a apparently reputable broadcaster does not give a warranty but accepts it has sole responsibility for obtaining the necessary licenses, he appears to have dismissed that as being a basis on which TuneIn could reasonably assume that the relevant operator was operating lawfully. Now, of course, these aren't, except in relation to Chorus in Canada Category 2, sample Category 2 stations. But the general point is he was, we say, dismissive in a way that falls into error of the importance, from the point of view of an operator like TuneIn, of such terms and conditions. On the face of it, where you're operating the sort of service that TuneIn is operating, with a very large number of stations indexed on the platform, and you have had particular agreements with stations where they've said that they're responsible for obtaining the necessary rights, that ought to be, on the face of it, a sufficient assurance to an operator such as TuneIn that the responsible party has the rights. Similarly, in relation to the BBC, well, it would be surprising if the BBC did not have the relevant rights, whether they accepted they should be given a warranty to that effect or not. The more general point as well in relation to the next few paragraphs is he makes a general finding about the significance of warranties, saying that if a warranty is being given, the effect of the warranty is, he says that such a warranty could be relevant, whether a tick box on a web page where reference to legal terms not even being read amounts to good notice to TuneIn that the internet radio station was making considered representation is not a matter I have to decide. Now, pausing there again, we say that the judge erred here in being overly dismissive both of the legal effect of the warranties that were given and also the significance to an operator like TuneIn. It's a short point, but firstly, ticking a box on an internet page by a commercial operator or indeed an individual is generally accepted, subject to some consumer, obviously consumer legislation, to signify acceptance of the relevant terms and conditions. So there's no reason to discount it or treat it as being unimportant. And secondly, again, seeking a warranty of this nature in the process of adding stations to its platform is a sensible way in which an operator like TuneIn can obtain assurances that the relevant party is acting lawfully. So we say in those passages he was also over-dismissive of the measures that TuneIn had taken to ensure that it was dealing with parties who were operating lawfully. Now, that may not, as I say, be directly relevant to his findings on Category 2, which were flawed for the reasons I've already said about the lack of addressing and considering the relevant findings in relation to each Category 2 station, but they do affect the way he approaches the issue of authorisation later, and therefore we say undermine his views in relation to authorisation. Now, turning to the next topic, topic 5 is targeting, which the judge considered earlier on in his judgment at paragraph 12, which is core bundle page 124, and after considering the principles, the facts, through to paragraph 34 on page 128. We deal with it in our skeleton at section E2 and also section G, but again, for the hopefully for the assistance of the court, I'm going to summarise and focus on really the central point in relation to targeting. Starting with the legal principles, we don't disagree with the judge's summary of the legal principles relating to targeting at paragraph 16 of his judgment. The problem is that when having correctly set out the legal principles, in our submission, the learned judge erred in the way that he applied them to the facts as he found them concerning TuneIn. And in particular, he didn't apply the principle that he summarised in Roman 5 in paragraph 16, where he explained it may be appropriate to treat a website as a whole, but in another case it may be appropriate to conduct a more fine-grained analysis. And then he goes on to give an example of different pages possibly being targeted in different places or not targeted at the same place. Now, he also correctly summarised the issue of how one approaches targeting in general terms at Roman 2, where he explained the issue of targeting is to be considered from the perspective of the public in the relevant state, i.e. the UK. In trademark cases refer to consumers or average consumers, because that's the relevant person in trademark law. For cases about communication to the public, the question focuses on the public. And he then refers to a couple of other authorities, including his own decision in Omniville. So the test here is, starting point is to note what one must consider is what would a reasonable member of the public think about whether a radio station operator was targeting the UK on approaching or using the TuneIn service. And in our submission, the problem is the judge made a non sequitur in his reasoning here, in that he decided that because the TuneIn website was targeted at UK users, it must follow that each of the individual radio station operators were also targeted or would be perceived as being targeted at UK users. And that, we say, is clearly a non sequitur, because there is a clear distinction, and there would be a clear distinction in the mind of a consumer, between the service which TuneIn offers, which is an index platform enabling people to find stations from around the world, and the service offered by the individual station, which on the face of it is being offered to whatever local audience that they have. An inclusion of a foreign radio station on the TuneIn platform does not objectively indicate to a reasonable consumer that that station is targeting itself at the UK, or the station operator is targeting itself as the UK. And the average or reasonable consumer or member of the public would know that TuneIn is in effect simply a convenient global platform with links to, directory links to streams of radio stations all around the world. TuneIn is, of course, not the only such directory. There are quite a few of them, various different types offer various different directories of stations to UK consumers. A member of the public would not infer simply from the fact that a foreign radio station could be found on TuneIn that that station was targeting its output at the UK, any more than a member of the public would assume if they did a Google search and found the station and started listening to it, that that station was targeting its service to the UK. Such a person would generally...
Why would it bother, Mr. Howe? Why would it bother to sign up and sign a station update form if it weren't intending to broaden its reach?
Well, my lord, it might well be signing up, as there was evidence about this, signing up because it gets better reach in its home territory. There was a German station that objected to being removed from TuneIn because it needed or wanted to be on TuneIn in order to get better access to its home territory. But, my lord, of course, the point is this: one looks at it from the point of view of the reasonable consumer. Does the reasonable consumer have any view on making use of an indexing website as to what the streams that are being connected to, or what is in the mind or the objective appearance of the intention of the individual operators? And in our submission, the answer is plainly no. They don't have any perception that just because a Kazakhstan station appears on TuneIn, that the operator of the station is taking it upon himself or herself to target the UK. It is a completely neutral act, the appearance on indexing website. And not least,
how is that submission consistent with your interpretation of Svensson, which is that all these radio stations have got their own internet website? And it's not that they're just broadcasting on their airwaves to the local population. They've all put their radio stations on the web. And Svensson says, well, in that case, they are taken to have assumed that anybody in the world can listen to them. So,
Yes.
so how does that then link up with you're saying, but even though they've put their radio station on the web, they're only targeting their local people?
But my lady, it's because the decision in Spencer and the issue of targeting are two separate issues. The decision in Spencer is concerned with whether a hyperlink is a communication to the public, and applying the CJEU's principle that one needs a new public. The decision in Spencer, the Court of Justice took effectively a policy decision that there was no new public where there was any material that was available to anyone freely on the internet, because the potential audience of any such material was anyone who could use the internet. So there could be no new public merely from hyperlinking. So that decision in Spencer relates to the scope of the communication to the public, right? Targeting is a separate issue to do with determining where the communication to the public takes place. So it's a jurisdiction issue, deciding whether there is an act of infringement committed in the UK.
Right, so even though in Spencer, the reason why there's no new public is because it's assumed that the person putting up the original website has taken into account everybody in the world. That taking them into account is not the same as targeting them.
That's right, Melody. That's absolutely right. The Spencer decision stands for the proposition that anyone who hyperlinks to material that is freely available on the internet is not committing an act of communication by providing that hyperlink communication to the public, because there is no new public. If there's no communication to the public, then the question of targeting doesn't arise, because the question of targeting only arises if there is an act of communication to the public. And the targeting principle is to determine where that takes place. It's explained by the judge in paragraphs 12 and 13 of his judgment. It's to deal with the fact that the internet is international. So it's a jurisdictional requirement that determines if a potentially infringing act has taken place, where it has taken place, and unless it has taken place, it's targeted at the UK, it doesn't take place within the UK. The problem particularly arises in relation to, for example, trademark cases, where there may be a website selling goods under a trademark, which there will be no license to sell them in the UK. And there's no infringement of the trademark unless the foreign website is targeting the UK in some way or another. But as the judge says in his judgment, the same would be true of a radio station operator, of course. If a radio station operator based in Germany were to take out ads, only had a license to operate in Germany, were to take out ads and say, listen to us in the UK, they might be treated as targeting the UK. And therefore they might be taken to be communicating to the public in the UK and infringing copyright. So it's a separate requirement, independent of the Svensson concept. So returning to the point I was making, is that it's a short point and in our submission reasonably obvious, which is that the judge conflated two very distinct things, which is what the TuneIn website, the service, which is a service, a platform of indexed hyperlinks of radio stations around the world, was targeted at. That is targeted to lots of different territories, but they include the UK, with the question of what would a reasonable user think on going on the TuneIn website and simply accessing stations using that service, which the answer is the appearance of a foreign operator's station on the TuneIn platform doesn't indicate targeting at all to a reasonable user. Simply shows that you can find that station through TuneIn, nothing more than that. And it's clear that the judge in our submission has gone wrong in his approach here, because his view that a station being on the TuneIn platform could amount to targeting, which is to say, turn the station operator from being a non-infringer to being an infringer of UK copyright, leads to extreme consequences, as one finds in paragraph 32 of his judgment.
Sorry to interrupt you, Mr. Howe. Just before you go on, where does the judge say that the station infringes as a result of this? The party that carries out the act of communication to the public is TuneIn. TuneIn is the infringer on this analysis, not the foreign station.
Well, my lord, he does conclude that the foreign station is an infringer, as I'll show your lordship in a moment. Indeed, that's the basis for his findings on authorisation and joint tortfeasorship.
Well, that's a separate question. Of course, there may be issues about authorisation and joint tortfeasance. Of course, we'll come on to that. But so far as the question of targeting by communication to the public is concerned, his conclusion that tuning communicates to the public is in no way dependent upon whether or not the radio station is an infringer, is it?
Well, my lord, what I'm dealing with here is his finding that if one looks at this part of his judgment, he is approaching the question of whether, well, it includes within it the question of whether TuneIn is targeting the UK, but also whether the radio stations themselves are targeting the UK.
I mean, I'm looking at his conclusion at paragraph 33. He says the acts of TuneIn radio complained of are targeted at the UK.
Yes, my lord, but if you look at 32, the fact that when an internet radio station is indexed by TuneIn and added to its database, there's no decision by TuneIn to target the UK when such a stream is irrelevant. Even if the internet radio station actually provided to UK readers was an obscure station from a country on the other side of the world, etc., that's irrelevant. When presented to a UK user by TuneIn, from the UK, the user's perspective is that it's targeted at that.
Exactly. So that's focusing upon what TuneIn does, not upon what the foreign radio station does.
Yes, but under authorization, he uses that finding as to what the station is doing in order to provide the basis for his findings on authorization. If one turns forward to paragraph 194, in fact, 192 to 195, under the heading Liability of the Providers of Category 2, 3 and 4 stations. This is page 162 of the core bundle. Where he says, the issue is not whether TuneIn commit an act of infringement, but whether the providers of the internet radio stations themselves are committing acts of communication to the public under section 20, when the station stream is played to a UK user through the TuneIn service and is therefore targeted at the UK. There are a number of different circumstances here. And then he says in 195, as one sees in relation to category 3, the effect of TuneIn service is that the internet radio station, assuming a UK user selected, is targeted at the UK. And similarly, he says at 194, the fact that the UK is one of the states targeted by TuneIn is no secret. However, this result will be true even for a provider whose streams are on the TuneIn service as a result of web crawler, who never signed up to TuneIn service since, aside from GS Media, which is looking at a different aspect of this. Section 20 is a sort of strict liability under UK law. So he arrives at a conclusion that a station can be infringing copyright in the UK under Section 20 simply by being present on the TuneIn platform, even if it has done nothing to join the TuneIn platform. One doesn't know that it's there, which on the face of it is a very extreme conclusion. But my lord, dealing with your lordship's point about the targeting section, to the extent that the learned judge is saying that if TuneIn is treated as committing an act of communication to the public, that TuneIn service is targeted at the UK, that's not an issue. TuneIn accepted, as he said, by the end of trial, that although its service was targeted at many countries, those included the UK. So there's no question that TuneIn service is targeted at the UK, but of course, that then presupposes or that's only relevant if TuneIn is communicating to the public by providing hyperlinks, which is the issue that we were discussing yesterday. But as one sees in paragraphs 192 to 195, he does indeed find that the station operators are to be treated as targeting the UK as a result of being on the TuneIn service.
I take that point, and I'm grateful for the clarification. But nevertheless, coming back to the point you were addressing us on, as I read 27 to 33, that entire page of reasoning is all focused upon the acts of tuning, not the acts of the foreign radio stations. Have I missed something?
Well, my lord, I must say I hadn't read it in quite that way. It appeared to me he was dealing with both the targeting of TuneIn and of the streams compendiously, and that then formed the basis for his finding at 192 to 195. But I should make clear that the reason I'm addressing this is in relation to the streams, the non sequitur, I say, that occurred in the judge's reasoning there, to the extent that he uses that analysis as the basis for his finding that the radio station operators are to be regarded as targeting the UK, which then forms the foundation for the authorisation joint tortfeasorship claims in relation to those acts. I say, for the reasons I've explained, that that is incorrect. He's gone wrong in his approach to targeting.
But you're not challenging his finding that the TuneIn service is targeted at the UK?
No. The TuneIn service, which is the provision of a platform of indexed stations, is targeted at the UK. I think it has a number of features that show that it is. So if TuneIn is, by providing hyperlinks, communicating to the public, then clearly, to the extent that happens via the UK platform, that is targeted at the UK. But that is obviously the very question, which is whether providing the hyperlinks is a communication to the public. I'll now move on to the next section, section 6, which is the question of the TuneIn Radio Pro app. Again, a point which I hope I can address fairly briefly, as it's a short point. We deal with this in our skeleton argument at section H. However, the nub of it is this. The TuneIn Radio Pro app was like the TuneIn Ordinary app, the standard app, that is included up until April 2017. A feature that allowed users to record streams that they were listening to. That was then disabled in April 2017. But there remains an issue in the case about whether there are two issues in the case about that. The first is whether the presence...
Explain to us, Mr. Howe, why does this matter? I mean, given the judge's other conclusions, why is this one relevant?
Again, my lord, it's one of the struts on which it's a finding of direct infringement made as against TuneIn. It's dealt with at paragraphs 176 and 177 of his judgment. It's an independent finding of infringement.
But would I be right in thinking that if the judge's conclusion in relation to category 3 is upheld, then this falls away? It only becomes relevant if he's reversed on category 3.
No, my lord, it doesn't, because it applies to all streaming on the Pro app. That's the argument. The argument that the claimants put forward at trial, and which the judge accepted, is that all streaming on the Pro app was an infringing communication to the public because the presence of the recording function changed the nature of what was taking place into an infringing communication to the public. It was a different technical means, in other words, was the argument put forward, and the judge accepted that. And we say the judge was clearly wrong to do so because he's confused.
Well, I'm sorry, Mr. Howe, but that comes as news to me. And the reason it comes to news to me is that if one looks at 178, he's looking at the 4 categories. He's not saying there's infringement in relation to absolutely everything.
He says it applies in relation, 177. He says that finding applies in relation to all three of categories 1, 2, and 3. So he found that even listening to UK stations on the Pro app was an infringement, even though he had found that the Category 1 stations, the UK stations, were not an infringement because they were operating lawfully within their territory.
I see, that's the point. Thank you for the explanation.
There are a number of moving parts in the judgment, my lord, but this is one of them. Anyway, well, what I was going to do was just address the judge's reasoning, which is really compressed into paragraphs 174 to 176, where he explains the line taken by the claimants. And just before I get to that, the point about the Pro app is that the position that TuneIn took at trial is that this is effectively a modern version of a radio cassette recorder. You can buy a radio with a cassette in it, a cassette recorder in it. You can use the cassette recorder to record broadcasts off the radio. If you do so, you may be infringing copyright in the broadcast, but it's simply a device that allows a user conveniently to record a radio broadcast. The Pro app effectively contained the same function. It enabled the user listening to a stream, if they wanted to record the stream that they were listening to, or parts of the stream they were listening to.
But with the radio cassette recorder, would that fall outside because of that exception that we looked at yesterday about, merely providing the physical means for doing it doesn't amount to communicating yourself. But here there isn't the same sort of physical means that you can point to, like you can point to the existence of a cassette recorder within the physical radio.
True, it's not described as simply physical means. It's not like providing a computer server or something of that nature. But the reason I was mentioning the analogy is because the question is what's happening when you sit listening to a radio on a radio cassette recorder without turning the cassette on. Answer is you're listening to a broadcast. You put the cassette in, you decide to start listening to record the broadcast while you're listening to it. Does that change the fact that the broadcast is a broadcast? No. Well, the judge found in this situation, in fact, the opposite was the case. He said the fact that there was the possibility that you could record the stream changed the nature of the communication to the public, so that it became a new technical means, and hence infringing even in relation to a UK station. The end result of that is this. A user listening to the, up to April 2017, who was listening to the BBC in the UK using TuneIn on the ordinary app, the judge held is not infringing, whereas a user who had the Pro app, even if he didn't record anything, would be infringing. And we say that that's plainly wrong, because the judge has muddled up two quite independent acts. One is the recording, which may or may not be the making of a copy, which would be a separate infringement of copyright. And the other is the process of receiving the stream, which may or may not be a communication to the public. But one cannot say simply because there is a facility in the app to allow copying, which may or may not be used, that it has any effect on the analysis of whether the receipt of the stream via the hyperlink is or is not a new technical means. And the error we say one can see is in paragraphs 174 to 176 of the judgment, where he notes, first of all, the line taken by the claimants is on the basis that the Pro app, including the record function, is a new technical means. They then refers to cases about that. And then he says, I find, in 175, I find that the inclusion of this feature makes a material difference to the nature of TuneIn's active communication via the app, at least when one considers users contemplating its use. And he says, when that sort of user selects and listens to an internet radio station using the app, which includes a recording function, it seems that one cannot describe TuneIn's service as nothing more than a form of linking, conventional or unconventional. And then he notes that we argued that the claimant's case muddled up two rights, the right to communication and the reproduction right, copying right. I don't accept that. And then he goes on to explain why he says that at the end, TuneIn has converted the internet radio station streaming service into a permanent download on-demand service. And it's our submission that that's simply wrong. The judge has indeed confused two quite separate things. There is the app, which is either allowing a communication to the public which is infringing or not infringing, as the case may be, which depends on the analysis about, we discussed yesterday about whether a hyperlink is a communication to the public or not, and if so, in what circumstances. And then there's the quite separate question of the recording function included in the app, and it simply makes no sense in our submission to say that the fact there's merely a facility transforms the nature of the communication to the public, the stream, from being a non-infringing stream in the case of the UK stations to an infringing stream. So we say the judge has fallen into error there and clearly gone wrong. One cannot say there's any change to the technical means of the communication to the public merely because there may also be a record feature, any more than having a cassette recorder included with your radio means that you're not receiving a broadcast anymore. They're both still the same process, and that's not a new technical means.
Well, he describes it as a download on demand service.
Well, that again doesn't change the nature of the communication to the public, if there is communication to the public. That remains unchanged regardless of whether or not the record function is activated. As I've said, if the record function is activated, then that may lead to the creation of infringing copies, and that's a point that he considered under the heading of authorization or joint torpedoship. But it's our submission an error to say that merely because one can record something off a stream or off the radio for that matter, that it means you're no longer receiving a broadcast or a communication to the public. If that is what is happening, it makes no difference. It's an independent activity.
I mean, given the figures that we saw yesterday of the preponderance of the radio, of the UK radio stations that are in Category 1, this presumably makes a big difference to the financial outcome of the case, whether everything broadcast to those UK radio stations before 2017. Well, it's only on the Pro, it's only the Pro app. So how many people roughly had the Pro app, do you know, as compared to the ordinary app? The importance of this.
There were figures about Pro app users. I will find out the number and provide it. It's somewhere in the evidence, I think, if I remember rightly. And hopefully someone will tell me fairly shortly. There are a significant number of Pro app users, but obviously there are a subset of the total number of users. What I remember, the great preponderance of users are free users rather than Pro app users, but there are Pro app users. So that's the Pro app, or the judge's finding in relation to the Pro app as representing in effect a freestanding form of infringement by communication to the public on the grounds of new technical means. We say that that's erroneous, and he has indeed muddled up the two separate acts of communication.
I think the answer to my lady's question is to be found in paragraph 180, isn't it?
Oh.
I mean, it's slightly off in terms of time, but it gives you a feel for the numbers.
Oh, thank you, my lord. I've forgotten that. You're quite right. Yes, over 150,000 users in January 2019, although the recording function had been turned off by then. Thank you, my lord. I was going to move to section 7 now, which is the question of accessory liability, which is dealt with by the judge at paragraph.
Just finishing on that point, I think it would be useful because obviously 150,000 in 2019, when the Pro app record function is not working, if there were 1 million in 2016, then that would, but it dropped off to 150,000 following the removal of the recording function, and that might tell us something interesting. So I think I would still, if it is possible, to get the Pro app figure just before the record function was eliminated, that might be helpful.
My lady, we'll have a look and see if those figures are available. They should be somewhere. I have a recollection that they were there was some evidence about that dealt with that. Let me just see. I'm told there may be a reference in the evidence if it's before the court.
Well, no need to take up time with it. You can come back to us on it.
Well, there is some evidence, though I think it's all from 2019 in this passage anyway. It's in the supplementary bundle in Mr. Straley's witness statement, which is tab 14 at page 35. Sorry, page 173, paragraph 35. That deals with the position as at January 2019. There's also a reference to some people complaining about the removal of the record function. 2,853 contacted TuneIn and the record functionality was removed. And as Mr. Straley notes in the evidence there, this may be because the majority of users who use the Pro version for the ad-free experience, not the record functionality, but I cannot say that for sure. My lady, I'll see if there are any figures about earlier in the...
That indicates that it wasn't a huge drop-off between... yes, if you could just double-check that.
Yes, I will. Turning to the question, therefore, of next of accessory liability. This comes just after the section where the judge has dealt with the recording function on the Pro app. And he starts this section on page 162 of the core bundle, paragraph 192 to 195 for judgment, which I've already mentioned, with a finding that by their presence on the TuneIn platform, whether they know it or not, the category 2, 3, and 4 stations, category 2 and 3 stations for present purposes, are infringing copyright by communicating to the public in the UK. Clearly, I already made submissions about that, which is even if one treats them as communicating to the public in the UK, the judge is finding that they are thereby targeting the UK by their presence on the TuneIn platform is incorrect for the reasons I've explained. And if that's right, then any issue of authorization or joint tortfeasance in relation to those communications by the foreign stations doesn't arise because there's no primary act of infringement to which TuneIn could be an accessory. If we're wrong about that, though, one then goes to consider the judge's approach to authorization or joint tortfeasance, which he addresses at paragraphs 196 to 203 of the judgment. 204, in fact, is the paragraph that deals with joint tortfeasance. And he refers to the authorities there, in particular an extract from 20th Century Fox and Newsbin. In our submission, the leading case on this area, which establishes what is required for the purpose of authorization, is the CBS and Amstrad case, which is in the authorities bundle, volume 1 at tab 31, page 540. this is the well-known case decision of the House of Lords concerning Amstrad selling a VCR recorders, which allowed high-speed recording of pre-recorded cassettes onto blank tapes, so double recorders effectively. And the House of Lords rejected the claim that by selling these items, that Amstrad was either authorising infringement of copyright or a joint tortfeasor in relation to the infringements by people who used the machines to do this. And the relevant passages are sidelined at page, using the PDF paging numbering 581 to 582 through to 584. And as Lord Templeman says in that speech, that Amstrad did not, this is at 581, letter C, Amstrad did not sanction, rather he pausing a bit above that, to authorise means to grant or to grant to a third person the right to do the act complained of, whether the intention is that the grantee shall do that to his own account or only on account of the grantor. In the present case, Amstrad did not sanction, approve or countenance infringing use of their model. I respectfully agree with Atkin, LJ and Lawson, LJ in the present case. In the context of the Copyright Act 1956, an authorisation means a grant or purported grant, which may be express or implied, of the right to do the act complained of. Amstrad conferred on the purchaser the power to copy, but did not grant or purport to grant the copy. And on the next page, at page 582, he also addressed a passage that was relied on in Laddie Prescott and Victoria concerning the question of inevitability. In other words, if it is inevitable when you sell something that people will use it to copy, does it follow that you are to be treated as having authorised that copying? And he rejected that proposition, letter B on page 582, after quoting from Laddie Prescott, the passage 1C, is a person may be said to authorise committed infringement if one has some more control over the other at the time of infringement, or if he has no such control, is responsible for placing in the other's hands material which by their nature are almost inevitably to be used for the purpose of infringement. And he rejects that. This proposition seems to me to be stated much too widely. As Whitford pointed out in the Ames case, and that was a case concerning a library that was lending, had a membership where people could join and borrow records, but would also obtain through their membership of the library blank tapes. And the claim that there was authorisation of infringement was rejected in that case as well. He then quotes 1C from Whitford and continues after that quotation. These borrowed records, together with all recording machines and blank tapes, could be said to be materials which by their nature are almost inevitably to be used for the purpose of infringement, but lenders and sellers do not authorise infringing use. So one needs, as this case establishes, authorisation, a grant or purported grant, express or implied, of the act in question, and the fact that one provides facilities that may inevitably lead to copying or infringement is not enough to constitute authorisation.
So, Mr. Howard, can I ask you this question? As one can see from paragraph 197, the judge in the present case applied the test articulated by Mr. Justice Kitchen as he then was in 20th Century Fox, Film Court and Newsbin, which took into account not only CBS and Amstrad, but a series of subsequent authorities as well. And the 20th Century Fox test has been applied in subsequent case law. Now, do you accept that that is the correct test to apply, or do you submit the 20th Century Fox is wrong?
Well, as we say in our skeleton, we submit that 20th Century Fox is wrong in one respect, if one looks at the quoted passage. And the respect is where, amongst the factors listed by Kitchen, J as he then was, is the factor whether it is inevitable it will be used to infringe. Because, as is clear from binding authority in CBS and Amstrad, it does not matter if the facility or whatever it is that's being provided by the alleged authoriser may or may not inevitably be used to infringe. And therefore that's not a factor that the court should take into account when deciding whether authorization occurs.
The difference between this and the double VCR or double cassette deck is that the double cassette deck can be used to copy a cassette of me singing or something, me singing a song I've composed in a way which is not then an infringement of anybody's. So there is the potential for it to be used in a way which doesn't infringe, and no one buying a double cassette deck would think that they were being sub-licensed, as it were, by the seller of the cassette deck to record an album, whereas here the function is only to record. You can't record anything that's not somebody's copyright work. And if I was using Pro App and and knew that it had a record function, and someone said to me, well, you realise that you're illegally copying the song, I would say, well, I assume Pro App was licensed to enable me to do that, as they're giving me the ability to record these songs that they're streaming to me. So I'm not sure that the analogy with the double cassette deck is quite accurate in this respect.
Well, my lady, that assumes that any recordings of any streams are necessarily are recordings of copyright material, which is not necessarily the case.
What might there be that isn't? What might there be streamed that isn't copyright material?
Well, there are stations that put out large quantities of chat or talk of one type or another. We focused in this case obviously on songs, but there's a huge variety of stations on the TuneIn platform covering all sorts of different genres, not merely songs, although it's accepted a significant number, obviously, as one expects of radio stations have a significant part of their output is songs or sound recordings of one type or another.
Can I just ask a quick question on that? I mean, you're of course correct that a lot of the content is not within the claimant's repertoire, and indeed a lot of the content isn't musical at all. But it doesn't follow that it's not copyright. That you can have copyrighted literary works which will be infringed by use of the record function.
I agree, Arnold. It doesn't follow it's necessarily not copyright, but certainly one cannot assume that all of it is. There may be there's a huge quantity, potentially, of a wide range of different types of material provided by these streaming services. Therefore, one cannot assume that it is. Also, of course, the authorization claim relates to two distinct alleged infringements. One is the copying on the Pro App, which we've been discussing, but the other is the allegation that there's authorization of infringement by the foreign operators if, as the judge found, they're communicating to the public in the UK. So there are those differences. It doesn't follow necessarily that the recording function will always be used to infringe. And anyway, the inevitability is not a factor. So, Madam, just concentrating on the quotation from 197, we accept it's a fair summary of the propositions, except the reference to whether it's inevitable it be used to infringe, because that is not a factor that one uses to decide whether or not there's been authorization. And therefore, the passage is erroneous to that extent as it's contrary to CBS.
But I mean, it comes back to the question I was asking you earlier, Mr. Howe. I mean, what are these radio stations doing if they're not authorizing TuneIn to effectively put forward their stations to users in the UK? I mean, assuming you're wrong about targeting, and it's perfectly obvious that they're authorizing the whole of TuneIn's function in respect of their content. And that's what, otherwise, why did they do it? Why did they sign the whatever the forms are called?
Well, my Lord, 2 points there. The first is that we're concerned here not with authorisation by the stations of TuneIn, but the other way round. The accessory liability here is whether TuneIn, on the assumption the stations were communicating to the public and infringing copyright in the UK, authorised the stations to communicate. So the issue is, in fact, the opposite, the other way around from the one your Lordship expected.
But they're complementary issues.
Well, they might be complementary issues, but I'm just focusing on the issue in hand at the moment. But the second answer to your Lordship's point is that one cannot infer in our submission anything about, on the separate point, which really relates to targeting, or the judge's finding about targeting. One cannot infer anything about the state of mind of a foreign radio station operator from the fact that they appear on the TuneIn platform, not least because in the past, and to some extent still now, the judge found, a number of them have simply been indexed on the TuneIn platform in much the same way as they may be indexed by Google without taking any active steps. Any website, of course, can take steps to remove itself from a search function, but if you don't actively do so, then you may be indexed in any event by any search engine, and that would include radio station aggregators. And of course, as one's seen with TuneIn, up to 2011, they were adding stations by simply finding them and putting them onto the platform. So one cannot infer anything about the radio station's intention, subjective or objective. And that relates to that, of course. The question is not what is the radio station subjectively intending, and if there is evidence about a subjective intention, that may be relevant, as is mentioned in paragraph 16 of the judge's judgment in his summary of the targeting issues. But it's not a central question about subjective intention. The real question is what objectively does a consumer or reasonable member of the public think, simply going to an aggregating platform and finding a radio station, to which we say the answer is one doesn't infer anything about the intentions of the radio station operator any more than you would finding them through Google. It doesn't indicate that they're targeting anybody. It merely shows that they're on a global radio station indexing platform, which is not very surprising. It doesn't show any objective intention of targeting any particular audience, any particular country. While I was on CBS songs, I just wanted to deal also with, while I'm there, on page 1584, the question of joint tortfeasance, where he summarises the principle in relation to joint tortfeasance at letter B. Joint tortfeasors are two or more persons who act in concert with one another pursuant to a common design in the infringement. In the present case, there was no common design. Amstrad sold a machine, and the purchaser or the operator of the machine decided the purpose which the machine should from time to time be used was capable of being used for lawful or unlawful purposes. But the point there is the principle in relation to joint tortfeasance is common design. And just to finish that topic on the principles applicable, of course, that's been restated recently in the C. Shepherd case, which is in the Vulnerable Authorities at tab 34. Now, after the CBS decision, that clear statement of what joint tortfeasorship requires, there were other cases in the interim that to some extent perhaps muddied the water about whether a common design was required. But Fish and Sea Shepherd, it's page 651, I should have said my order of the authorities file, tab 34. Sea Shepherd re-established the orthodoxy and made it clear that there must be commission of the tort pursuant to a common design to do the acts which constitute the tort. There are a couple of, this is a case obviously about a conservation charity vessel and whether there was a common design in relation to people involved in the vessel in damaging nets and damaging a boat. But the statements of principle are quite brief and very clear. In Lord Toulson's judgment at page 661, paragraph 21, he summarises the requirements for common design. To establish accessory liability in tort is not enough to show D did acts which facilitated P's commission of the tort. D will be jointly liable with P if they combine to do or secure the doing of acts which constituted a tort. This requires proof of two elements. D must have acted in a way which furthered the commission of the tort by P, and Dean must have done so in pursuance of a common design to do so, or secure the doing of the act which constitutes the tort. Do not consider it necessary to desirable to gloss the principle further. And to similar effect, Lord Sumption, after considering the authorities, emphasised the same point on page 688 at paragraph 44. Referring to the question of intent. And in the middle of that paragraph, between B and C, what the authorities taken as a whole have demonstrated is the additional element which is required to establish liability over and above mere knowledge, otherwise lawful act will assist the tort, is a shared intention that it should do so. And a combination of active cooperation and commonality of intention encapsulates in Scruton and LJ's distinction between concerted action to a common end and independent action to a similar end. Between either of these things and mere knowledge of the consequences of one's acts. And to similar effect.
Well, before you go on, could I ask you what you have to say about the last sentence of paragraph 43 of Lord Sumption, where he says the creators of a file-sharing website were held liable for copyright infringement even though the site was capable of lawful use, because it was found on the evidence the defendants not only assisted the infringements, intended them as an effective way of increasing the use of its website. And I think you will find that that's exactly how the claimants put their case in here.
Well, my lord, a file-sharing website is a very different creature to the platform such as TuneIn. The common endeavour there is to enable and facilitate the sharing of infringing materials, infringing copies of copyright works. So in my submission, it's very different facts, but also doesn't detract from the point which I was drawing out of the judgment here, which is that the Supreme Court has re-established the need for a common intention. And to similar effect, at page 670, in the judgment of Lord Neuberger, he summarises the three elements at paragraph 55. Again, the second of those being the act must be pursuant to a common design on the part of the defendant and primary tortfeasor of the act be committed. And similarly, he emphasises the same point at paragraph 58. There must be a common design. And at 59, he deprecates as an unhelpful gloss, potentially dangerous gloss, the suggestion in previous cases of looser terminology, such as agreed on a common action. Sorry, wrong sentence, second sentence. The notion that a defendant, concerned about the notion the defendant has to make the tortious act his own, which was one of the phrases that crept into the cases from Lord Justice Peter Gibson's judgment in the Sabat case. And he says, to the extent it rightly emphasises the primary common design, that the formulation is circular, potentially dangerous gloss. So it's a re-establishment of the rigour of the joint tortfeasorship elements. With those points in mind, I turn briefly to the judge's findings in relation to authorisation. He notes at 198 there's two sets of what he says are infringing activities. One is the acts of communication to the public by the internet radio station in categories 2, 3, and 4, and the other is the recording of the user's of the Pro app. This is page 163 of the core bundle. And he starts with the first one, which is the acts of communication to the public by the radio stations. And obviously this rests on the hypothesis that these radio stations are in fact committing acts of communication to the public in the UK, which we say is incorrect for the reasons I've explained, and that even if there is a communication, there's no targeting by the radio stations of the UK. If I'm wrong about that, however, one moves on to consider the question of whether tuning can be regarded as having authorised that. And again, in relation to that, we say that the various factors he's listed don't amount to authorisation within the tests laid down by CBS and Amstrad, applying the test laid down by CBS and Amstrad, which is TuneIn purporting to authorize infringements or provide a right to infringe by the stations from the perspective of the user? The answer is no. Very much the reasons I've explained in relation to targeting, which is that the mere appearance of a station on the TuneIn platform, given that TuneIn is a global indexing service, doesn't indicate anything about the content of the stations, whether they are infringing or not infringing, whether they have licenses to broadcast the UK or not. It's an entirely neutral act that doesn't provide any indication that TuneIn is authorising a particular station or warranting that a particular station has rights to anything in particular. It's simply saying this station is on the internet, this is its name, here's a stream. It's no more than that. The same is true in relation to the Pro app. We say that the Pro app copying, this is the copying aspect of the Pro app. The Pro app copying is a function that the user can use or not use, as the case may be. They may use it in a way that creates infringing copies, or they may not, depending on the content that they copy. But the mere presence of a function is stands in no different position to the provision of a radio cassette recorder in the old days, or other similar functions. Indeed, many modern devices include within them recording functions where you can record screens or record activities and so on and so forth. All of that is simply a fairly standard part of technology. It's completely neutral and doesn't indicate any authorization by the provider of the facility that someone is entitled to or not entitled to copy anything. As regards joint tortfeasance, which the judge dealt with very briefly in paragraph 204, in our submission, he simply didn't apply the right test, and that he needed to consider whether in relation to either of those acts, the broadcast by the foreign stations or alternatively the copying by the users, there was evidence that supported a common design to commit those acts. And in our submission, there was no evidence to support such a conclusion. And therefore, there was no basis for saying there was any joint tortfeasance. On the contrary, there's no reason to think that any of the radio station operators have any particular view about whether their streams are listened to or not in the UK. There's no reason to conclude that any particular user has any view about whether or not, when they record, it's something that TuneIn is cooperating with them in or not. It's simply entirely neutral. There's an absence of the necessary element of common design to support a finding of joint tortfeasance. I'm nearly at noon, and I have one last section to complete, if I may, which is the question of the position from the 1st of January 2021, and whether he... Is
that going to take you, Mr. Howard?
My Lord, I would estimate approximately half an hour, maybe 20 minutes.
Right, well, we'll take a 5-minute break now and resume at noon. Thank you.
Thank you, my Lord.
I can see we have Lord Justice Arnold. Not sure about Lady Justice Rose. Lady Justice Rose has just arrived. Mr. Howe.
Yes, my lord, the Court of Appeal, since the 1st of January this year, as you know, has power to depart from EU retained case law, and the regulations provide that in deciding whether to do so, the court should apply the same test as the Supreme Court would do, or the House Laws would previously have done, in the well-known practice statement of our judicial precedent of 1966. That's in the bundle at tab 47, page 1059.
Yes? Seem to have lost Mr. Howe. Have to wait for him to return, hopefully quickly.
My Lords, I apologise on Mr. Howe's behalf. I'm making inquiries to determine whether he's suffering from a technical glitch.
But I think he obviously is suffering from a technical glitch, since he simply disappeared from our screens as he was about to tell us about the practice statement. But yes, thank you. Let's hope he'll return. I've just invited him in actually again, so hopefully he'll be with us shortly. It's the kind of problem that I've encountered when you have a power cut or something like that and the internet simply disappears, so he may take a minute or two to restore his connection. Here we go. Mr. Howe, you're back. You need to unmute. Mr. Howe, can you?
Yes.
You're back? You had an internet problem lately.
Yes, I'm very sorry, my lord. My system simply shut down for no particular reason.
Yes,
I apologise.
That's what I thought. Please continue. We're at the practice statement and Lord Gardiner's dicta there. Oh dear. I suspect that it'll take the same amount of time to reconnect as it did last time. Mr. Howe.
Yes, my lord, I'm sorry about that. My computer was acting up, so I've switched to a different device, which I hope will be more reliable. I do apologise for wasting your time.
No, I don't think it's your fault. Please carry on with the practice statement.
Yes, my lord, the practice statement, as one sees at page 1059, provides for the competing considerations here, which is the requirement there should be some degree of certainty, but nevertheless, that too rigid adherence to precedent may lead to injustice in a particular case, duly restrict proper development of the law, and therefore one can depart from previous normally binding decisions where it appears right to do so, which is clearly a broad and general test, having regard to the, as I said, considerations of legal certainty, but also the need to avoid injustice and to unduly restrict the proper development of the law. We've cited in our skeleton a number of cases where this point has been considered. It's probably only necessary to look at one by way of example, as they don't necessarily do more than a simple gloss or explanation on the practice statement. At tab 39, one has the authority of NAWA and the Ministry of Justice. Which is in Joint Authorities at Bundle 1, tab 39, page 786 of the PDF. And the relevant passage for these purposes is the marked passage on page 786. Paragraphs 22 and 23. Where, having referred to the practice statement, Lord Neuberger then notes Lord Bingham's speech in Horton and Sadler, not least because the desirability of certainty of the law just discussed, however, as Lord Bingham said in the same passage, while former decisions of the House are normally binding, too rigid adherence to precedent may lead to injustice in a particular case unduly restricted about law. And the court should be very circumspect where accepting an invitation. However, they decide they ought to do so in the present case. You don't want to explain why in that case they should take a different view. With that test in mind, I turn to the question of why we say this is an appropriate case where the court should depart from retained EU law on the issue of communication to the public. The relevant principles of EU law in this area are well known and have been described by a number of cases, including summarised by my Lord Justice Arnold in one of the passages quoted in the judgment in the present case, I'll come to in a moment. But the relevant principles include the following difficulties, we say, in relation to EU law in this area. The first difficulty is the definition of communication. Now, communication as conceived in the Berne Convention and also as defined in the Copyright Act itself is said to involve an electronic transmission or diffusion in the Berne Convention, but it involves one or the other. And of course, in Article 23 of the Information Society Directive, as we've looked at previously, the same terminology is used, where it's also stated that it should include acts of transmission, but no other acts. So it's intended to be anchored, the concept of communication, in some form of electronic transmission. As interpreted by the Court of Justice, however, it's become completely untethered from that root origin, and therefore is at variance with the international treaties from which the right derives. It's said to involve...
Just before you go on, Mr. Howe, can I ask you a fundamental question here? We know that Article 8 of the WIPO Copyright Treaty defines the right of communication to the public as including, but not being restricted to, the making available right.
Yes.
And the making available right is framed in terms which embrace the potential for transmission, even if there is no actual transmission. Would you accept that?
I do, my lord, yes. Quite so.
Right. So it follows that the communication to the public right must also embrace the potential for transmission, even if there is no actual transmission.
Quite so, my lord. I agree entirely with what your lordship says, but it doesn't follow from that that it embraces things other than potential transmissions. If the question is whether X has made something available, then it may be that X makes it available by providing the opportunity for the transmission to take place, but they must at least do that. Absent, unless the alleged infringer has engaged in an act which is a transmission, were it to be acted on by a user, then there is no communication in our submission. And the problem with the CJEU's approach to this is that, as I say, it's become unmoored from its proper foundation in the international treaties from which it's supposed to derive, and indeed unmoored from Article 23 of the IMSO Directive itself, and has now become a slightly vague and amorphous concept, which is said to involve, non-exhaustively, an assessment of whether the person intervened with the full knowledge of the consequences of his act, which also, apart from being vague and difficult to determine, imports into this area of restricted acts and primary infringement concepts of possibly objective or subjective knowledge of the actor, again, which is not what's envisaged by the not consistent with the approach in this area of the law, and also is not something that's contemplated by the treaties. The second problem with the CJEU's approach, we say, is the approach to the definition of the public, which includes, again, concepts which are essentially judge-made and have no obvious basis in the treaties. The two elements in relation to this are, firstly, the CJEU has fashioned the concept of a new public, which in itself requires the assessment, hypothetically or otherwise, of what the copyright owner might have contemplated as being the public that he had in mind for his first communication. So the first poster, in order to determine whether there's a new public or not, and this is a general application in this area according to CJEU jurisprudence, the first person who makes the first act then has to try and infer in some way or another what that person must have contemplated as being the potential audience for whatever the communication potential or actual was to be. And that too, we say, is not something that has any basis in the treaties, and is also unhelpfully vague and requires a difficult and potentially indeed impossible assessment of what a hypothetical rights holder, or possibly an actual rights holder, might have had in mind when he did something. Secondly, on relation to the concept of public, the CJEU has also introduced a gloss, as we know, in relation to new technical means, which is they say that one is deemed to be communicating to the public if there's a new technical means, but not otherwise unless there's a new public. And again, the concept of a new technical means is not something that derives from the treaties or is found in the Infosoft Directive itself. It's a judicial creation. The third problem with the CJEU jurisprudence, we say, is the rule in GS Media, which is another gloss on an already rather shaky structure in relation to communication to the public, where the CJEU has introduced into the question of primary infringement an issue of the state of knowledge of the alleged infringer, with presumptions in favour of the non-profit-making user and against the profit-making hyperlinker. And again, we say this is an unhelpful introduction of what are essentially elements of secondary liability to what ought to be a relatively objective and clear determination of primary infringement. And in addition, the CJEU's reliance on the relevance of profit-making is also, we say, not consistent with the treaties and doesn't derive from the treaties. That should make no difference for the purpose of infringement, whether you're acting for profit or not, save in respect of the well-known exceptions for private study and research and so on and so forth, all of which are spelled out in, amongst other places, Article 6 of the Information Society Directive that are well known and provide a measure of immunity or protection for certain private activities. The fourth problem with CJEU jurisprudence, we say, is the suggestion or holding that the question of whether a communication to the public has occurred or not involves an individualised assessment of interdependent criteria. That, in our submission, deprives the concept of communication for the public of any principled or coherent analysis. In other words, looking at it both from the point of view of the rights holders and the users, the law in relation to the communication to the public as established by the CJEU doesn't involve considering, firstly, whether there's a communication, and secondly, whether there's a public. In some extremely vague and generalised way, also an overall assessment, whether the individualised assessment of the various criteria relating to each other in order to decide whether there's an infringement or not. And we say that's not consistent with the requirement that intellectual property, like other species of property, should be clearly and objectively determined in a way that's accessible to users and rights holders. So we submit that the right approach here is that the communication to the public should be put on a proper footing, which is to say by reference to the two elements. The first is that there should be a communication, and a communication should involve a diffusion or an electronic transmission, or in the case of the making available right, a potential diffusion or electronic transmission. That we say is consonant with the Berne Convention and also with the WIPO treaties, and also, of course, consonant with the definition of communication to the public in Section 20 of the UK statute, which defines it as being a reference to communication being to an electronic transmission. Secondly, as regards made to the public, we suggest this is a familiar concept, which is to say it involves a communication to people outside the private circle. There is considerable case for another discussion of what this involves. It's typically taken to mean not possibly a small family circle, but it depends on the circumstances. It needs probably more than one person. It needs a number of people, but not necessarily at the same time. It can be people sequentially, leading to a large number. But it's a well-known and manageable distinction between the concept of a private communication and a public communication, which doesn't present any particular conceptual difficulty. Next, we say that these two elements are not interdependent in some amorphous sense, but need to be considered in turn in order to establish where there has been or has not been a communication to the public.
So let's assume we accept your invitation and go for the simple scheme that you've just proposed, which certainly has some attractions to it. But why, if we applied that approach, would we not conclude that your clients are indeed communicating to the public in the present case? Because there can't possibly be any suggestion that this is communication to a private circle, and there is indeed an actual potential transmission.
No, my lord, there is no transmission from a hyperlinker to a user. That is why there's no communication. I was about to deal with the question of hyperlinks. As your lordship knows, there's a debate between various different schools of thought in relation to the status of hyperlinks. We've included in the bundle, obviously, the opinion of the European Copyright Society submitted in relation to Svensson, and also the counter opinion, as it were, or view of the International Literary and Artistic Association. They're in bundle at tabs 100 and respectively in 96. And we've also included some of the references to the academic articles, such as Professor Hugenholtz's article, which is at tab 104. But all of these points of view, I should also mention we've included, as of this morning, the further materials your lordship mentioned, which is to say the guide and glossary to the White Book guide and glossary.
It's not your fault, Mr. Howe. Thank you for all of that. But the problem is, where do you stop? I mean, let's take LAE, for example. So you've given us the Executive Committee report from 2013 on the occasion of the Congress that year, when they adopted the report of the study group chaired by Professor Rosen and with significant input from Professor Ginsberg. But you don't give us the other two parts of the trilogy, which are the reports of the study group that were adopted in 2014 and 2015. Now, I appreciate you have to draw a line somewhere, but it does mean that inevitably there's some difficulty in how one approaches this. Because on the one hand, I forgive you for attempting to be selective, because you can't possibly give us everything. But on the other hand, on what basis do we look at what LAE said in 2013 without looking what they said in 2014 and 2015?
Well, my lord, it's a fair point. I confess that I was concerned anyway about the volume of the authorities, and therefore we did have to draw the line somewhere. There's obviously a great deal more material on this debate that could have been put before the court, and I apologise if we've omitted material that that your lordship would think to be helpful. But coming back to the question that your lordship raised, which is as regards hyperlinks specifically, we note there's a disagreement about how one treats hyperlinks. But what we say is this: a hyperlink, at least to material which is freely available on the internet, such as we have in the present case, links to radio stations which anyone can navigate to without any difficulty, not hidden in file lockers or tucked behind paywalls or anything of that nature, is not a communication to the public by the hyperlinker, because no transmission occurs of any work from the hyperlinker to the user. The transmission, when it occurs of copyright work, occurs from the server of the radio station to the user.
But how is that consistent with your acceptance that communication to the public embraces potential transmission as well as actual transmission? So that's exactly what the hyperlink is. It's a potential transmission.
Well, my lord, it's not a potential transmission. The hyperlink is simply a method by which, it's a signpost by which someone is directed to the place where they may obtain a transmission. The party who provides the electronic transmission is the site to which the link leads. A hyperlink is simply, as I say, a signpost or a footnote. It's not in itself any form of communication.
I thought what you were saying is that when the hyperlink is used and the potentiality is realised, even then it's not a transmission by you, it's a transmission only by the radio station.
Yes, that's right, madam. There's no transmission by the hyperlinker at all of the copyright work. That's the diagram we looked at the start of my submissions in the judgment, where the judge noted the way that the system worked. It's not controversial, it's fairly well known. So a hyperlink, as I said, at least in relation to material which is freely available, is not a transmission at all, communication to the public at all, because there's no transmission. Any more than, for example, we could have provided our skeletons to the court electronically with links to the authorities referred to as hyperlinks. It's sometimes done. It doesn't mean that we're communicating the authorities to you, we're just telling you where you can find them. What communicates the authorities to you when you click on the hyperlink is Bailey or Justice or wherever the authority resides. You click on the hyperlink and then click on the download, then that's the party that's providing the communication to the public. The question of the liability of any hyperlinker in those circumstances is solely a question of secondary liability or accessory liability, which is to say a hyperlinker may be liable for joint tortfeasance or for authorising infringement if they're doing more than simply providing a hyperlink, and in some way, as it were, as one sees in some of the pirate systems, they're providing a structure by which they appear to be offering the infringing content and so on and so forth, and that can be decided on the basis of secondary liability in the ordinary way without the need to try to insert or shoehorn these or distort the concept of communication to the public. Now, we also accept that there may be other cases of hyperlinking, for example, where the hyperlink is to an obscure or hidden file locker, or is structured, the service that's being offered is structured in such a way as to allow pieces of copyright materials to be assembled from different hyperlinks or so on and so forth, which are out of the ordinary, that may, in certain circumstances, be treated as communication to the public because they could be regarded as making available the works. But that is an issue in our submission for another day, because that's not what TuneIn does. It provides straightforward vanilla hyperlinks to radio stations that are freely available, nothing more and nothing less. So, my Lords and my Ladies, that's why we say that this is an opportunity to put the law on communication to the public on a proper footing. We also say in the alternative that even if the court were not prepared to depart from the CJEU jurisprudence to the extent you've suggested, you should, in the alternative, depart from the CJEU jurisprudence when it comes to GS media. Because if one takes the jurisprudence up to the point of Bestwater, which established a clear rule in relation to hyperlinks at least, which is that generally speaking they were not communications to the public because there was no new public, GS media has added a conceptually confused superstructure to that clear position in the form of states of knowledge, depending on whether the person in question is profit-making or not, which is unhelpful and obfuscates the position greatly and allows neither rights holders nor users to have any clear idea about whether what they're doing might or might not be regarded as infringing or not when they use a hyperlink, which in turn greatly impedes and has potential hugely to impede the proper functioning of the internet by making it very uncertain for anyone using a hyperlink that they might be accused of having the necessary knowledge, either actually or inferentially, that the link led to somewhere where someone had posted something without permission. So we say in the primary case, this is an opportunity to restore the law on communication to the public to its proper footing in the elements that we've described, or alternatively, if that is a bridge too far, then you should instead, in our submission, not follow GS media and treat the law as it stood up to Bestwater. And ultimately, there's also reference by both parties, like we started, I take responsibility, to various other jurisdictions, such as Australia and the US and Canada. There's a dispute between the parties about whether those cases show that in those jurisdictions the courts have taken the view that the hyperlink is or is not, generally speaking, to be regarded as a communication to the public. I don't propose to take time on those because the position taken across all the authorities is not entirely clear, and the different courts have taken a slightly different view. When they've taken a different view, in some cases, although not actually in Australia, contrary to respondent's suggestion, not that it matters, it's because the terminology of the statute is slightly different. For example, in the States, they have the communication to the public right includes the concept of displaying the work, which changes the court's approach to embedded hyperlinks, or has at least in one case, although not in others. So I wasn't going to take up time on the foreign law unless the court thought it would be helpful for me to do so. And my Lord, finally, for the sake of tidiness, before I finish this section, is my Lord Justice Arnold asked us to indicate what it was we disagreed with about the previous decisions of the Court of Justice. And I thought it would be useful to do this by reference to Your Lordship's summary of the principles, which is quoted in the judgment to indicate what we say about them. It's in the judgment on page 131. It's from Your Lordship's judgment, my Lord Justice Arnold's judgment in the Paramount Home case, where it's a summary of the principles that's been cited on a number of occasions since, including in this judgment. And looking at the principles, we say as follows in relation to these. 12.1, communication to the public must be interpreted broadly. We agree that's correct. Secondly, communication to the public covers any transmission or retransmission of the work to the public not present at place where communication originates by wire or wireless means. Again, we agree that's correct. Thirdly, it does not include any communication which is carried directly to place open to the public by means of public performance. Again, that's correct. Fourthly, there's no communication to the public where viewers have no access to an essential element which characterises the work. That's correct in the sense they must be saying that in those circumstances there's no infringement because it's not a substantial part of the work being communicated. On that assumption, that we agree with that. The fifth point is expressed too broadly. They say communication includes any retransmission of the work by a specific technical means different from that of the original communication. It may well be so that a retransmission by any party other than the original organisation making the first transmission is a communication, but it doesn't follow that a particular technical means has to be different. And it may include different technical means, but it doesn't require to include different technical means. Sixthly, the proposition that a mere technical means to ensure or improve reception of original transmission in its catchment area does not constitute communication. We would suggest not necessarily so. It may constitute a communication if it's an electronic transmission, or it may not. It appears it would be likely to do so, so 6 is probably incorrect in many cases, but it's not correct in all cases. 7, also, we suggest is not a correct way of framing the act of communication. An act of communication when someone gives members of the public access to the work in circumstances where they're not be able to enjoy the work without his intervention. That states the nature of communication too broadly, because communication is not simply about giving access, it also involves an electronic transmission or diffusion, and therefore that is potentially includes acts which would not fall within the scope of communication. 8 to 12 are uncontroversial. At 13, we say is incorrect. We say that it is irrelevant whether communication is profit-making or not. 14 is rather specific, but we would say would depend on the circumstances about a dentist's office, a particular case, that it would depend on the circumstances. If there's a communication and it's to the public, then it may well be a communication to the public, depending on the assessment of the clientele, etc., and when they constitute the public. 15 also, which is the embodiment of the different technical means concept, or the new public concept, we say is also incorrect for reasons I've explained. There's no such requirement. The assessment of a public is simply whether there's a public or not. 16, again, is the concept of an elaboration of the concept of new public, which we say is incorrect for the same reasons. And 17 also is incorrect, and it says that there's a communication to a new public, and again, we do not accept the concept of a new public as helpful, and therefore elaboration of it doesn't help. And 18 is also different technical means, which we say is incorrect for the reasons I've explained. So, my Lords and my Lady, that's my submissions on that subject. But my last topic was the respondent's notice. But I can leave any points on that in relation to reply, and will only be any short, very short anyway.
Yes, I think you should. Lady Justice Reyes, any points for Mr. Howe?
No, thank you very much.
Lord Justice Arnold?
No, thank you.
Thank you, Mr. Howe. Mr. Cullen?
My Lord, I'm grateful. If I could just start by stepping back a bit and putting this dispute in context and to see the big picture. What one has, my Lord, is a situation where there are tens of thousands of foreign radio stations. Now, they each have their website targeted at their domestic audiences, one can assume. There may be stations which target more broadly, but for the purposes of the case, one can assume that their own websites target their domestic audiences. In a world without TuneIn, UK copyright is not engaged by those stations' activities at all. They do not communicate to the public in the UK because they do not target the UK. UK rights holders have nothing to say about them. Now, well, in steps TuneIn, and suddenly these tens of thousands of stations are targeted at the UK. That is the whole purpose of the TuneIn service. And as a result of that, one has an act of communication to the public in the UK, and UK copyright is engaged. Now, before developing that slightly, it may be convenient just to look at the TuneIn terms and conditions about which we've heard much, but we haven't looked at them. And the ones in force over largely the relevant period are in the supplementary bundle at tab 4, page 21. We may look at these for another purpose in relation to the warranties later, but just to draw your Lordship's attention and your Ladyship's attention to one particular point, which is the basic point in clause 1, towards the top of page 21, which govern the your use of the service, this is directed to the stations, to make available the transmissions of your station and any sound recordings of musical works and other content, etc., to TuneIn's global audience of listeners. So, my Lord, my Lady, that is what the service is for. It is to enable these foreign stations to be targeted at TuneIn's global audience. The result, and Lady, is that someone is sure as hell communicating these words to the public. The question is who? The judge, correctly we say, found that both TuneIn was and, or it could be, but he found both, and the stations do, by virtue of TuneIn's intervention. Now, my learned friend has to say that neither does. He does this by a series of contortions. So when contending, for example, that his client doesn't commit the act of communication, he relies on the warranties which everyone has supposedly signed up to. But then when saying that the stations do not, he seeks to suggest that a lot of them might be there unwillingly and have not signed up. So, my Lord, we'll come back to those points. What, my Lord, TuneIn also relies upon, importantly, is on foreign licensing positions. And so he says, in effect, that where there are stations which are licensed abroad, that is sufficient for his purpose to mean that there can be no new public. Now, the effect of that, my lords and ladies, is that the UK copyright owners are being deprived, on my learned friend's case, of their ability to consent or not consent to the act of making available that is undoubtedly taking place. As a result of, this is in relation to category 3 stations, of a territorially limited license, or, more extremely, of a situation where the local rights regime grants statutory license or equitable remuneration right to the local right holder, so that those stations are operating lawfully there. And my learned friend's case relies on that as giving him a leg up to make it legitimate, then to retarget the stations at the UK. The effect of that is that the UK rights holders are deprived of their right to control copyright by legislative act of foreign jurisdictions. My lords, that simply cannot be right, we say. It means that in effect the UK right is exhausted by foreign legislation. Moreover, my lord, one of Mr. Howe's repeated answers to this supposed problem is to say, well, the answer is to impose geo-blocking on the foreign stations so that rights holders can prevent them thereby making their content available to the UK. But my lord and my lady, that is simply not open to rights holders in circumstances where those stations are operating lawfully under statutory licensing schemes or equitable remuneration schemes, because the stations are doing nothing wrong. There is no means, through licensing solutions or others, whereby rights holders can impose a geo-blocking solution. So, my lord, lady, we say that if one views it from that perspective, the judge's conclusions that both TuneIn and station operators were committing an act of communication to the public in the UK is unavoidable. And I'm going to develop that in stages as we go through. My lord, before doing so, if I could just say this, there are many grounds of appeal, as we know. To an extent, one can't blame TuneIn for that, because it needs to succeed on a lot of different bases to avoid liability as found by the judge. But that said, there's a difficulty in getting to grips with this appeal, exacerbated by the way in which the skeleton argument tends to ignore the judgment. My lords, there are various points in it where TuneIn seems to want to reject the judge's findings of fact and his evaluative judgments, but without identifying those in relation to the appeal, let alone explaining why the judge was wrong. Just for a couple of examples, my lord, paragraph 200, subparagraph 3. I'm sorry, subparagraph 2, at page 163 of the core bundle. The judge makes findings about TuneIn's respect for rights holders' position, effectively. My learned friend, in his written argument, seeks to suggest that TuneIn is a respecter of copyright and generally a good citizen. My lord, that is inconsistent with the judge's finding, and that appealed, that finding is not appealed against. Similarly, my lord, paragraph 76 of the appellant's skeleton argument, the appellant says it would be impractical to discern licensing arrangements in the context of what checks could be made. That, my lord, is flatly contrary to the judge's findings at paragraph 148, where the judge finds specifically that the number of stations is not so large as to make the necessary checks unduly troublesome, etc. My lords, my lady, in relation to that particular point, the practicality of making checks, there was considerable debate before the court below in relation to sources of information. For example, in relation to this question of whether stations are licensed for the UK, PPL has a list, and one can simply ask PPL and they will supply it. Similarly, in relation to the position in the States, Sound Exchange publishes various lists, and there was a lot of debate about the significance of those lists. Your lordships haven't heard any of that evidence, and it's not being gone through. What one has is a clear finding from the judge that making the necessary checks would be simple, and that is not appealed against. And your lordships must obviously proceed on that basis, and not on the basis that is proposed in my learned friend's skeleton argument. My lords, now we are faced with an appeal against the entire corpus of European authority in this context. My lords, I have to say this came as a surprise to me. If your lordships look at the grounds of appeal, so far as they touch upon departure from EU law in the core bundle at page 15, paragraph 21, invites departure from European authority solely in relation to hyperlinking, as your lordship will see at paragraph 21. The court is now being invited, on the strength of about 20 minutes of submissions, to rewrite the entirety of the law in relation to communication to the public and reject, as my learned friend put it yesterday, the entire corpus of European learning on the subject. Quite apart from that, not being...
Mr. Cullen, you may have observed that Mr. Howe was allowed to complete those submissions in rather short order, and it occurred to me that they were ambitious submissions and beyond the scope of the notice of appeal. But I would certainly urge you not to respond, not to use your submissions to spend all your time on that latter ambitious part of his submissions, but to concentrate on the earlier and less ambitious parts, because that's where we will be most assisted, I feel.
My lords, I'm certainly going to concentrate on what we say matters in the case.
I'm not depriving you of a little forensic flourish to start, Mr. Cullen, but I just didn't want you to warm to the theme of trying to dissuade us from overturning the entire corpus of European law on this subject.
My lord, I'm certainly not going to deal with it at this stage. I will come back to it towards the end. My lord, I'm going to move on now to just consider some factual aspects before getting to the law, because there's a question about the evaluation one makes of the service as a whole. Of course, the judge had the benefit of all the evidence. He had the benefit of copious written submissions, 250 pages from TuneIn, less than half of that from our side, but nonetheless, he had a lot. And he made various evaluative judgments, and your lordship should obviously be very slow before going behind those. Now, what Mr. Howe invites the court...
Can I just ask something, Mr. Cullen, that I probably should know, but you can help me with? Of course, this case was tried by Mr. Justice Henry Carr, and I see that submissions took place in front of Mr. Justice Henry Carr. It was I, as Chancellor, who asked Mr. Justice Burst to take on this case after the sad loss of Mr. Justice Henry Carr and his inability to complete the judgment. But what I'm not quite clear is what procedure he adopted, which may be relevant to some of the factual submissions you're making, and I would certainly like to know. Obviously, he read everything that had gone before, but then did he have new submissions from you both?
Yes. Yes, my lord. What happened was he read everything that had gone before. He also indicated that Mr. Justice Henry Carr had left the partial judgment, and he asked the parties whether they minded him reading that, and both parties agreed he could, but we have no knowledge as to how far developed that was. And then we all reconvened for 2 days of oral submissions.
Thank you very much for that.
Now, we'll address the characterization that is urged upon the court by Mr. Howe, which is to say that he presents TuneIn as being a mere provider of links, and he invites the court to proceed with its analysis on the basis that that's what it does, and that's really all that it does that is relevant. We say that is a reductive and entirely unrealistic characterization. As the judge found, TuneIn is a provider of content, and specifically, it's a provider of music content. One sees that at paragraph 129 of the judgment. That's an evaluation which isn't challenged on appeal. It is quite wrong to regard TuneIn as just a sort of referencing service or a location tool. What it functionally provides, and certainly the way it will be perceived by users, is as a provider of music content. Now, one can see the description generally in the judgment, paragraphs 5 to 11 and 123 and following. Just drawing out some of the features, these are obvious, but they perhaps need stressing. It has a music section. It has curated recommendations of music stations. In the context of foreign stations, perhaps particularly notable that it has a feature which it calls Spin the Globe, whereby it recommends particular foreign stations that it wants to urge upon its users. In the UK, they will obviously be foreign to UK users. It provides artist searches. Formerly, it provided even song searches. More or less an on-demand service. That song search functionality was stopped as a result of claims and assertions made in the US by rights holders, but who knows, it might be reintroduced. Now, to enable it to provide these search facilities, it gathers metadata of what is being played on the stations. It gathers that in 2 ways. First of all, it invites stations to feed it into the API, or via the API to TuneIn itself. It also goes out of its way to collect the metadata from the stream as it passes from the station to a user. It uses that metadata, as I said, lady, to enable it to provide the search facilities so that someone can, to use Master of the Rolls illustration yesterday, find Elton John being played by a Slovakian station. It provides artist pages. Music performers have specific pages which will show stations playing their content which will give you the song title of the particular recording being played. One sees that, just for your Lord, for the court's note, at Mr. Grant's first statement, paragraph 54. I won't take the court to it now. It's at tab 15, page 197 of the bundle. It goes to the length even of arranging to be able to provide cover art.
Is that the core bundle or the
I'm sorry, my lord, that's the supplemental bundle.
supplemental at 197?
197, paragraph 54 of Mr. Grant's statement. From Mr. Grant's statement, the court will also see it provides cover art from albums that the artists have released. Again, that is in the supplemental bundle, tab 15, page 205. That's 32.4 of Mr. Grant's statement. Now, one could go on, and I commend Mr. Grant's statement, the extracts of it, which are in the bundle. If your lordships wanted the full view, which the court had, obviously there would be more evidence. But my lord, it all goes to demonstrate the ways in which TuneIn provides music content specifically to its users and provides a tailored and curated environment whereby that content is promoted and pushed in certain ways by TuneIn. Then it's important to consider the way in which that content is provided. The user receives the stream without leaving TuneIn's site. This is an important feature, we say, and certainly the judge held. If your lordships turn to paragraph 128 of the judgment, the judge refers to this specifically. This is page at Little Romans 3 and 4 at the top of page 152 in the core bundle. Now, the reason why it's important is for at least two particular features. First, it goes to the quality of the intervention in making the content available. To the user, it appears to be coming from TuneIn. So that is part of the way in which the intervention appears to TuneIn's audience. The second point, my lord, is that it has economic significance. And this is where one comes to Lord Hoffman's urging to follow the money. Your lordships were taken to the way in which one navigates to sites by Mr. Howe yesterday. I'd just like to repeat that exercise and just draw out one or two points which my learned friend didn't draw out. First of all,
Mr. Cullen, I wonder whether that is an exercise that would be better begun at 2 p.m.
My lord, that may be sensible.
I have a feeling you probably won't complete it in less than a minute. I take it that your submissions are on track to finish in how long?
It's hard to predict, my lord. I would hope to be finished by lunchtime tomorrow, but I'm not promising that.
At the latest, I hope, Mr. Cullen. I'm sure that gives you plenty of time. Very good. We'll resume then.
I'm sorry, my lord. Could I just mention? I don't want any time that I don't use up through the economy of my submissions just to be filled by Mr. Howe in reply. I take it that any reply Mr. Howe would have will be subject to some sort of guillotine.
Mr. Howe has already used up nearly all his time, apart from 25 minutes. However, we won't be dictatorial about allowing him to reply to points that you make, because we want to hear both sides' submissions in this important case. That's more important than imposing strict time limits. What I wanted just to make sure was that we didn't spend more time on the case than we needed to. Okay, 2 o'clock.